Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I am the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And today I'm going to talk a little bit about the recent Circuit Court ruling involving Maryland's General AFO Discharge permit that was recently ruled to be not adequate by not including ammonia emissions discharges that could enter the air as a pollutant and then come back into the water. So we'll talk about how the court came to that ruling and what that means moving forward. So let's get started with, talking about that. So if we look at it, back in March, we had a circuit court ruling that reversed the Maryland Department of the Environment, or MDE's, final 2020 animal feeding operation, or AFO discharge permit for not considering ammonia emission discharges into the air as a pollutant into water, since the ammonia discharges could fall into waters covered by the Clean Water Act and covered by other state laws. MDE, I need to point out, and as I'm recording this, I do not know the outcome of the final decision on the appeal or not, so this may be updated once we figure out what's happened. MD does have the option to appeal the decision, but as of right now, we do not know if that's going to happen, so I'm putting this out ahead of time. So let's give a little bit of background on this. So MDE began work on reissuing the AFO discharge permit in 2019 and allowed the public to comment on the draft permit during the process. The Assateague Coastal Trust, or ACT, provided comments during the comment period related to gaseous ammonia discharges from concentrated animal feeding operations, or CAFOs. In particular, ACT had concerns that the permit did not adequately address discharges of air pollution, including ammonia, from exhaust fans and manure storage areas into the air and surface waters. MDE responded to this concern by pointing out that EPA does not regulate odors and air quality through the Clean Water Act permitting process. Because MDE derives its authority through that delegated to it by EPA, MDE consequently also refused to take odors and air quality into account. MDE issued the final permit in July 2020 with no limitations on ammonia emissions. So let's look at the circuit court ruling. So ACT filed a petition for judicial review in the circuit court for Montgomery County on the final AFO discharge permit for not limiting ammonia discharges. Typically, courts will defer to an agency's interpretation of law unless that interpretation erroneously interprets the law. If a ruling is an erroneous interpretation of law, then the court can substitute its judgment for the agency's interpretation. To the circuit court judge in this case, the Maryland General Assembly broadened the Clean Water Act's reach in the state with water quality legislation passed to provide additional remedies to the state's waters. Included in this expansive view was the use of the word admit by the General Assembly in the definition of discharge. Looking at the dictionary definition of the word admit, the court determined it would take into account gaseous emissions such as ammonia from a poultry house fan in a gaseous state. MDE argued that this interpretation would broaden the existing law and require MDE to regulate chimneys and cars for potential gas discharges that could hit waters in the state. To support this, MDE cited a federal case, Chemical Weapons Working Group, Inc. versus U.S. Department of the Army. In that case, the case they cited, a group argued that pollution caused by the incineration of chemical weapons would fall to the earth and land in waters covered by the Clean Water Act, requiring the Army to get a discharge permit first. The 10th Circuit Court of Appeals refused to construe the Clean Water Act to require a permit for air emissions. The Circuit Court disagreed with this decision, supporting MDE's argument because incinerated chemical weapons were authorized by congressional action. The General Assembly had not provided similar authorizations to allow ammonia discharges. Incinerating chemical weapons to the court was a one-time event and possible CW Clean Water Act violations were insubstantial compared to the potential repeated violations by animal feeding operations here. The circuit court ruled that MDE erred as a matter of law by not including gaseous ammonia emissions and reversed the AFO permit's final determination. So why do we care about this? It's important to note again, it may likely be appealed. We don't really know at this point. If MD does not appeal, then they have to look at how to, the options in implementing the ruling. That may take some time for them to work through and figure out what they're going to do. The things I want to note here that we need to look at are, one important note is that the circuit court quickly rejected the 10th Circuit decision as not on point. The 3-judge panel in that 10th Circuit decision found that taking the chemical working group's arguments to regulate emissions from incineration of chemical weapons would create a direct conflict between the Clean Water Act and the Clean Air Act, the federal law regulating air emissions. In that case, the Army had received the necessary permits, including a Clean Air Act required permit. To the panel, this direct conflict would create an irrational result of regulating air emissions under the Clean Water Act and not the Clean Air Act. If we compare this to the circuit court's decision, and that's all I'm doing, I'm looking and thinking, how do we compare these together? Here we have an activity currently exempt under the Clean Air Act. The EPA does not require air emissions permits for animal feeding operations, but a circuit court ruling now would regulate these discharges under water pollution statutes. This appears to create the conflict between existing federal laws that courts typically try to avoid in these situations when interpreting statutes. The court also does not deal with EPA's views that point sources of air pollution become non-point source pollutions of water pollution once they go into the air. We're dealing with a point source of gaseous emission from a CAFO, typically through a poultry fan or some other method. Under EPA's view, MDE would appear to be acting appropriately in considering the discharge a non-point source of water pollution that is not covered by the Clean Water Act. Again, that's my interpretation of what I'm seeing in the law. With that said, this decision is going to have real-world implications. If you're listening outside the boundaries of Maryland, this ruling probably will have no impact on you. In Maryland, it could have some real impacts. We'll have to wait and see what those will be, just depending on what the agency's final view is and how they end up either appealing or not appealing the decision. So we're kind of in a wait-and-see method on this. So thank you for listening to the podcast. If you have any questions on this, I provided some reference materials in the show notes, so you can click on that and read it as always. If you have any questions on anything else or ideas for future shows, please let me know. You can email me at lgoering@umd.edu, or you can tweet me or send me a message or find me on Instagram, all at @aglawpaul. Thank you again for listening and enjoy the rest of your day.